I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into our 41st compilation video. We're going to be in 3 different judges' courtrooms. Before I give you that rundown, just know that there will be chapters added to these videos, and also that there will be no commentary at the end. As always, I appreciate you guys for joining me for these compilations. I appreciate the feedback, the love, you guys sharing content, sharing information. All of it has been amazing. And with that being said, guys, let's go ahead and name the different judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Alex Manning out of the state of Georgia. Second, we will be in the courtroom of Dane County, Wisconsin. And third, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. So as always, I appreciate you guys for joining me for another compilation. And with that being said, guys, let's go ahead and jump into these proceedings.
Kapuma.
No, your last name.
I am Kapuma.
Okay. What's your last name? Wimbishi?
Kapuma is my last name.
Okay. So what's the first one then?
Wembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they have it reversed? Okay.
So it's Wimbishi Kapuma.
So your name is, like, your last name is Kapuma then?
My last name is Kapuma.
Okay. We'll make sure didn't want to destroy it, too bad with my accent. So I guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not necessarily. That's just a typo, but
yeah, but according to this,
we're just kind of getting started here. Okay. So I'm just trying to pronounce your name right. That's basically all that is. Okay. All right. So this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay. So we got 285 days without indictment. He had a Feretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. You swear affirm testimony about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so 1 second. So, sir, what this is a preliminary hearing. Okay, it's just to establish that there's probable cause. So the DA is going to ask some questions, and then you get to ask follow-up questions. Okay, all right. So go ahead, Ms. Fields, and this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department, and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapuma.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the 4th floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the 4th floor. We go to the right where the clubhouse was, and we found a white male victim named Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed, the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious.
Okay.
during that time.
So he was unconscious?
He was unconscious, but he was not unconscious when we arrived on scene. But
You were gaining consciousness.
yes, ma'am.
Okay, now you said that this happened at what address?
Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that that Mr. Kapuma rendered this man, Mr. Unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay. And did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I'm talking
Okay.
about,
All right.
what happened with that?
So during the incident while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr.?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or just resistance? There
was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. And he said that Mr. Johnson was concerned about how Mr. Kapuma was acting.
Yes. So
can you describe how he was acting and what you were told?
Yes. So what I was told by the victim is that at some point this was a company event that was going on, and during the course of the event, at some point, the defendant had put, according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the defendant act in this manner before. Mm-hmm. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
Altercation happened?
Mm-hmm. Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges? Pertinent to this case?
That's pertinent to this case, no.
Okay. So I have for right now, it's your witness, Mr. Kapuma.
All right, Mr. Kapuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh, okay.
You can't see him on your.
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by, Mr. Kapuma. What is your question?
So
who, what, where, why, when?
So in that situation, who was the aggressor in that situation? Because he put his hands first on me.
Just ask a question.
Mm-hmm.
So based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
So is there a written signed statement from the witness about that incident to describe what you're saying, so that they sworn like a sworn affidavit?
What,
Who,
where, why,
I'm
when?
gonna have to object. Compound question. Can we?
All right. So you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay. Next question.
So there's body camera for the entire event from all 5 officers of what happened?
Yes. So my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
So I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that event.
Well, all of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
That's actually,
he's been testifying, and so we object to testifying.
so did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Next question.
was based on my understanding.
No. Next question. If you want to say something later, you can, but what's your next question for him?
Okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
You said stand up?
No, I told him to stand by. I didn't know if you had an objection.
Yes, I have a judge. I understand you're giving him leeway, and I understand the reason for that. However, counsel has been not asking direct questions on cross, and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
What's your next question? What's your next question for him?
Because for me, it's mainly about consent and jurisdiction.
Okay, hold on.
Mhm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right.
Okay.
Anything else with the officer?
I do have some redirect.
Okay, go ahead.
So, officer, I know I was calling this. That was my mistake. I meant to say the correct, but the correct victim's name is Johnson. Is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma.
Yes, ma'am.
Okay, and that's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically, not really.
Okay. Thank you,
Okay.
officer. Stay safe
Thank
out
you.
there.
Thank you very much, Your Honor.
Have
Stay
a
safe
good
as
day.
well.
All right. Go ahead with the argument. What's here from the state?
So, Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Johnson's brain useless by, rendering him unconscious for a period of time where he did, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the willful obstruction, we understand there was no violence or offering of violence against, the officers and Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's the name of a strawman or a corporation. So that does not apply to me. It says the accused is capitalized. That's a corporation, and the strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case, because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction because I operate under common law. That's my jurisdiction, common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the gold fringe on the flag and the eagle at the top, which shows this is the maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my unalienable rights, if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the constitutional unconstitutionality of any situation, was overturned by the Supreme Court. So in this situation, yes, I did react to Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people will tase me. The officer will shoot me. But if the same thing happens to me, he touched me first. I reacted off of that. That's self-defense.
Okay, anything else? All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now bond. Let's see. All right, now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for terroristic threats act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place. Yes, Mr. Johnson, he was rendered unconscious. The punch that, counsel is trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that a $30,000 bond is sufficient.
All right, so it'll be no further contact with Johnson. Stay away from Peachtree Street Northeast. You're going to have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still going to live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right. So just supply a good address to the jail upon release. So 15,000 count 1 and count 2 is reduced to misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
We have here is Mr. Griffin.
Anthony. I'm biased for assistant counsel, not counsel.
We'll go on the record in the state of Wisconsin versus Anthony Griffin Jr., case number 25CF 939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family.
All right, so Mr. Griffin,
appearing expressly.
wait, you need to stop talking. Is Mr. Griffin
appearing expressly.
hearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin
of the
that is
estate
charged?
of
Stop a
Anthony.
second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25CF 939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later
I object, as I've been held for 72 hours without seeing a judge. That is unlawful.
But you're not Anthony
So
Griffin.
you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this, okay. I'm gonna find probable cause that this is Mr. Griffin, that is acting in an obstructing way, but we'll go ahead with it. Do you have a copy of the complaint there in front of
I
you?
object that you're obstructing my justice.
Your objection is noted.
I'm a more, you have.
If you keep talking over me, we're gonna cancel
You've been
this.
talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
And you're not allowed, no, you're not allowed to talk about it.
Of attorney. I am not.
Okay, let's hold them in custody or canceling this hearing. You're gonna have to be
That's
held.
okay.
You're not willing to cooperate. Make a record.
Show that they're violating my rights. Let the record.
Record and note that he refused to cooperate so that an initial hearing could be conducted. That's 25 CF 939 appearances.
ADA Sister Marco for the state.
Understand order with the defendant's office defers to Mr. Griffin, who's indicated that he wants to take care of his own case.
Right, is that right, Mr. Griffin?
I'm not Mr. Griffin, Anthony of the defendant. I am the power of attorney for him. I do not question for the court will be allowed to speak freely or will my civil rights be again granted over.
Oh, you gotta make a statement on bail, but we're gonna do this in an orderly fashion, but you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself?
It's not about me identifying myself and the Griffin carries in my all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am on board. So a lot of things on here are totally wrong, which not be at all. My weight is not 240 pounds. All this information is false. But as for the record, all statements for the record comes now the living man and the other Griffin family. Sure, there is appropriate son status appearing expressly to continue direct arrest accordingly. I'm not to be mistaken with the all caps state as I am the occupant of the executive office and also the sole beneficiary of the state. I filed my power of attorney with the court and I'm ready to proceed. Let the record show that I do not agree to be a surety for the dead entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed support was due to the failure of the court to notify me of said date. Furthermore, upon being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued with the arrest as a violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of coercion after I told them I did not want my fingerprints or paper taken until I have a court order from the judge. I do not argue with any of the facts in this charging incident. This is not me taking a plea. This is accepted for value and returned for value. All the charges incidents in this case and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they call Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir. You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about. I've never heard that ever.
That also means that this
you can file your written motions, Mr. Griffin.
Court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the Spillman records match this particular individual. I'll find probable cause.
Man can be awarded over his own case.
And where would you like us to send mail, sir?
You already have mail. I told you on file. It's P.O. Box, the Forest, Wisconsin.
Okay.
53532.
Thank you.
And I have a right to be
what's the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 cash bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the respective statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of bond conditions.
I object.
It's our position that
Wow.
cash bail is
Let her
necessary.
finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
The
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled.
Overruling objection.
I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, they're sure or not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for one?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that. And I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was, I don't know, hiding in the back or whatever the case may be. I filed an abatement, just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be
She's
doing any of that,
as the
Mr.
state,
Griffin.
and she is not the state. I know her not, so I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're gonna have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000 cash bail is necessary. I will set that.
I object, and it's clear
And
that
that's
these
fine.
rights have been violated, and you're still moving forward. This is called an obstruction of justice.
Don't
Let
think
the
that
record
your
show
rights have
that.
been
Know
violated.
everything that I've said.
It's all being recorded, Mr.
I'm
Griffin.
glad.
You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
But I don't want to sit in jail any longer.
Okay, well, you're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, that means
You're
you don't
gonna
have
have
authority
to,
over
you're gonna
me.
have to address
I object.
that
If you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
Are you
statute.
responsible for that?
And because I haven't heard a response, I don't believe we have a waiver of time limits to set a time
Are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned. Mr.
Okay,
Griffin.
since you're not responsible for me if something happens to me, let the record show that you are not. You are crazy. Bad communication, us.
On the Samsung, good morning to you. I just let you in on the Samsung. What's your name, sir? Samsung in the blue t-shirt. In the blue t-shirt, walking around the house.
Okay, did I get it fixed now? Did it get
What's
fixed
your
now?
name, sir? Good morning to you.
Antoine I'm Antoine. I'm representing
Oh,
this,
you're Antoine Pierre.
yes, yes. Try to get it
Latin,
fixed.
from the Latin family, right?
Yes, yes. Can you hear me and see me?
I can hear you and see you. Let me get you identified on here. All right, let me see where you're. Who was the other individual on the iPhone?
I don't know. I only got I only got a
I'm not
Samsung.
talking to you. I'm not talking to you.
Okay. Who's on the iPhone?
Did I get the iPhone person? They never connected the audio.
Sherelle Oldestone.
No, they never connected the audio.
Can you hear me?
I can hear you. I can hear you. All right. Let's go back on the record with Latney. So, Mr. Latney, state your name for the record, please.
I'm making a special appearance. I'm Antoine, the natural man. And here goes his topography, all capital name, Antoine Pierre Latney Bond that you guys are questioning. I'll make a special appearance on this.
Mr. Latney, I have no clue what you're holding up or what you're talking about.
Yeah, that's the birth certificate. I'm holding up the birth certificate of Antoine Pierre Latney.
Okay. And who is Antoine Pierre Latney?
That's I'm the natural person, but the all capitals name, which is topography that you are dealing with the all caps, that's this birth certificate. I'm not that all capital name. The all capital name is this birth certificate right here. I'm the natural person.
I don't know what you're talking about. You're confusing me.
I'm confused too. I'm confused too.
Okay, well, we're both confused. I need to see Antoine Pierre Latney. That's who I need to see.
I'm Antoine in the natural form, flesh and blood, right here. How you doing?
So you're Antoine Latney, right?
No. Are you referring to the all capital name?
Bro, we trying to go. You making this longer than it got to be.
I know it.
I'm gonna pass the matter until I get Antoine Latney.
Okay.
All right, Mr. Latney, let's get this over with. Yeah, let's do this because it's gonna linger on. And Mr. Latney, let's go back on the record with Antonio and Antoine.
For the record, I'm making a special appearance. I'm Antoine Pierre Latney, and I'm making a special appearance for this bond. I do not assume any responsibility for the all capitals name that you guys have in front of you or anywhere else.
Your Honor.
Yes.
All right, I'm gonna put my appearance back on the record. Cherika Harris on behalf of the natural person, Antoine Latney. And I will ask for a breakout room, but I am ready on Johnny Gatewood if we could do that matter first.
We'll get Johnny Gatewood out here. But you know something, Ms. Harris, I don't know if Mr. Latney knows that we get a lot of attention from these bloggers and these
well, it's just that it's like I drive for a living, but when I get into my regular car,
Mr. Latney, if I were you, I wouldn't talk. I mean, well, I'm sorry, you might not be Mr. Latney, but the person representing, I wouldn't talk if I were you. Give me a moment to speak with you in the breakout room before you make a whole lot of statements on the record, please and thank you.
Oh.
Okay. All right. So let's I'm gonna put you in a breakout room, Mr. Latney. Have a conversation with you don't object to that, do you? Having a conversation with Ms. Harris?
No.
So have a conversation with Ms. Harris and just wait on her. I'm gonna get Mr. Gatewood out of here and then we'll hear what you have to say, all right?
Yes, sir. That's great.
Right. Join the room, please.
Yes.
All right. let's go back on the record with Latney. Mr. Latney, what is this? How is this dismissed, Ms. Harris?
Your Honor, I've had an opportunity to speak with Mr. Latney. I was able to ascertain that he does have insurance that expires December 2nd, 2024. He did show me his receipt. Mr. Bowman was kind enough to take the receipt for the registration. And he also showed me his Georgia license that was issued in January of 21 and expires March of 29. My understanding is that would take care of the matters that were before the court. We would ask the court to adopt the recommendation to dismiss.
All right. If that's the recommendation, we will adopt it and to get Mr. Latney on his way. Because I don't know how you check a Georgia license, but we'll adopt the recommendation. Mr. Latney, you still owe $174 for an expired plate, an old expired plate, and $108 for an old no valid registration. All right.
Your Honor, if I can inquire as to how old those are?
They're too old for me to set aside. I can give you the date, but I'm not going to set it aside.
Thank you, Your Honor. I thought I would try.
Yeah, you can't help but try. That is the last year, April the 8th. Dismiss for providing.
Thank you, Your Honor. Mr. Latney, those matters were dismissed, but you do have some that still have to be paid.
All right, Mr. Latney, you understand that?
What was what's the criteria?
No, you just owe 2 old civil infractions that you never paid. An expired plate and a no registration, $174 and $108. The other matters that the court calls in the record are dismissed. All right.
Okay.
All right. Have a great day, sir. Best of luck to you.
Thank you. You too.
Good job, Ms. Harris.
I'm not threatening you. Say one more word and that's 30 days. 30 days.